Hello, thank you for being here. Thank you, Tom, for giving this talk to us. Apparently, we get to learn how to read legalese.
Sounds like fun.
Sounds like fun. So, before we start, I need to thank the sponsor of this room, which is Q, an IT and digital talent firm in LA focused on finding local technology talent for their clients through deep involvement in the so-called tech community. I would also need to remind you to fill up your survey and feedback talk about our presentation and our presenter. You can find the link in your schedules and also in the rear back of your badge. So the last talk of the day is about understanding free and open source licenses without a lawyer. Free and open source licenses are a key part of how FOSS works, but most of us do not fully understand how or why they work. After reviewing over 350 licenses for Fedora, Tom has seen almost everything and can share his wisdom with you. In this talk, he will go over the commonly used FOSS licenses, describe how they work, and even point out some of the unique licenses on the fringe of the universe. Thank you.
Thank you. So when you're filling out the survey, be sure not to mention that the speaker encouraged you to murder the fellow goers. That somehow is against the social code of this conference, and I do not encourage that. All right. My name is Tom Callaway. I am a senior software engineer at Red Hat. I have been for 14 years now, which means that I have seen a lot of weird and wacky stuff. And I will try to share the normal and give you some advice, help you to understand how to parse licenses. Unfortunately, I will not expect that people coming out of this talk will be able to immediately parse new licenses because, quite frankly, that takes a long time to be able to correctly interpret their wording and their meaning and how they flow. But I'll hopefully give you some tips and some ideas and some feedback, and we'll talk about some common licenses and how they work and what they do so that you can come away with a better appreciation for the common licenses you see. And then we'll get to the thing that everybody really wants to hear, which is the weird and crazy stuff that I've seen in my license time. So, let's start out with a disclaimer. I am not a lawyer. I did not go to law school. I have not passed the bar. I am not licensed to practice law anywhere. Again, I am not a lawyer. I am required by Red Hat to say this repeatedly and clearly. That said, I consult with lawyers on a regular basis on matters relating to free and open source, so I generally do know what I'm talking about. Now, as a general matter, only a lawyer may give actual legal advice, whereas any non-lawyer may recite legal information. Furthermore, it is generally illegal for a non-lawyer or an unlicensed attorney to offer legal advice or otherwise represent someone other than himself or herself in a court of law. This means I cannot help you with your divorce case no matter how much you email me. Also, everything I'm going to talk about here is either general knowledge, stuff you can Google, my own opinions formed by years of experience working with free and open source software communities, or legal information presented by a non-lawyer without pretense. If you need legal advice, get a lawyer. I can recommend some to you, except if you're in a divorce case, in which I can't.
That lawyer advice?
No. Now, very quickly, hopefully everyone here does not need me to explain in depth what open source is. Is there anyone in the room that does not understand open source? Great. But if you distill open source and free software, which I use those terms generally interchangeably, we could have several lengthy talks about the difference between free software and open source involving the singing of the free software song and readings from Eric Raymond's seminal texts, but we won't do that. Not today, not here, not now. We're going to assume that they are functionally equivalent for people who mean well and follow the spirit that's intended behind both. So sometimes I'll say free software, sometimes I'll say open source, sometimes I'll say FOSS. If one of these terms offends you or you like one more than the other, pretend I said the term you liked. But distilled down to a simple set of buzzwords, the core concepts are share, collaborate, and remix. Share is something that children do without thinking. It's only that we get older that we sort of develop the concept of ownership. We put up the walls and the barriers. We start saying, this is mine, this is not yours. When we share our knowledge, our skills, our talents, our insights, our experiences, and our resources, we get to the places we want to go faster. In the context of software, by sharing not just our binaries but also our source code, we share control over that software. Now, there's a Vanilla Ice joke in this slide, and sometimes I give this presentation and people are like, who's Vanilla Ice? But our understanding of the universe has made it functionally impossible for anyone to be a jack of all trades. We each possess our specializations, our strengths, our weaknesses. At the same time, we got this bonus digital interconnectivity of our world, where it's simpler for us to work together across languages and time zones and societal barriers with people that do have the skills that we lack. Collaboration in an open source context brings together people who have an itch to scratch and empowers them to build one excellent scratcher instead of 100 mediocre ones, unless it's an IRC client and then they're just going to build another one anyways. This also relates to something called Linus's law, which is given enough eyeballs, all bugs are shallow. Collaborate. And remix. And again, this is sort of an obvious concept if you think about it, because we all stand on the shoulders of the people who have come before us. Our parents, our teachers, all the way back to the first caveman to make his own fire. We take what we have, what we know, and we build on that. If you had Legos as a child, you eventually get to the point where you're spending more time building your own creations than the sets that you get. Lots of people end up with a state where they got a tub of Legos from somebody else, either as a hand-me-down, and there were no instructions, there were no models, it was just box of Legos, go build something, build a robot, build a spaceship, build a giant house and kick it over. The very nature of Lego gives you the freedom to remix. Art, music, cooking, gaming, all of these fields are derivative. We take what we like and what came before and we change it into something new. Why should software be any different? This happens whether we want it to or not. When you put barriers up for remixing, it only slows people down a little bit. And the people who keep moving fast by cheating the rules are the ones we adore and we worship. I believe that deep down within us, we are all hackers of something. And open source says, this is fine, this is cool. All right, terminology, because we have to have some slides with words. I'm not a big slides with words guy anymore. I used to do this for a long time, where I had these slides and it was like 14 bullet points and people are frantically scribbling down notes. I don't do that anymore because I can give you a copy of the slides and you can read them to your heart's content with all the notes and the scribbles that I'm reading off of. But terminology is good because legalese is a terminology language. If legalese was a programming language, it would all be header files. So here's a couple pieces of terminology that are important to keep in the back of your mind as we go through and we talk about how licenses work and how open source licenses work. Copyright is the legal rights granted to the creator of an original work by law. That is really synopsized. That's really super simplified. The actual definition of copyright from a law dictionary is pages and pages and pages and pages and talking about what is a creative work and what isn't a creative work. But that's a simple enough discussion for software. Legalese, which you will not find defined in a law dictionary, is a cryptic language used by lawyers, which seems to resemble English from a distance, but is not actually English. It is as if you went to the restaurant and you picked up a menu and you said, I will have the fish, and they brought you chicken, and you said, I ordered the fish, and they said, well, in legalese, chicken is fish. It's a little bit like the Pope telling you it's okay to eat beaver because they're not sure what that is, but it's probably okay. No, really, look that up if you're curious. It's funny. Look about, is it okay to eat beaver during certain holidays? Software license. A document written in legalese, not English, which tells the user what they can and cannot do with the software they possess. Now, in the United States, creative works are copyrighted when fixed in a medium. There is legal precedent to say that when you scribble something on the back of a cocktail napkin, you have established copyright because you fixed it in a medium. You don't need to register copyright to possess it. You possess it as soon as it's fixed in a medium. But it's generally considered not the worst idea ever to register it because it makes it easier for you to collect damages. It's not impossible to collect damages if it's unregistered. It's just more complicated. Copyright in most of the world grants the following legal rights to the copyright holder: the right to make copies, the right to be credited,
the right to determine who may adapt, perform, and/or benefit financially from the work. So essentially, the copyright holder is the person that has control over the work. Now, normally, the copyright holder is the creator of the work, but there are a fair number of cases where this isn't true. It's very, very common for employment contracts to sign over copyright from employees to employer as part of the standard boilerplate. So unless you talked to your employer and they specifically excluded that, which Red Hat does, by the way, it's kind of cool. But lots of other companies don't. So when you come to work for them, if you didn't read the small print and you were just so excited about the number of zeros that were in your salary that you just did, yes, sign, how am I going to sign this? You may have inadvertently given them all the copyright to everything you create, even when it's not on the clock, which is kind of interesting if you don't work for a software company and you write software. So there are several cases of people who wrote really cool software that was not part of their day job, that was not related to their company's industry. It started to take off and sell well and do a little successful side business, and that company decided that they wanted all of the profits that you made off of their software. So read your employment contract if you are employed, which, you know, one can hope, and check and see whether you assign your copyright to your employer or not. Now, why am I telling you all about copyright and legalese and software licenses and all of that stuff? Because open source and free software is all based on a clever legal hack or a magic trick. So let's talk about a proprietary software license, what it does. Now, I'm sure that when you get a proprietary application and it pops up, you spend all the time reading it and you go through it and check it thoroughly for all the clauses. Somebody recently found that Apple listed certain real estate properties in their EULA. Why? I have no idea, but they do. But really, I'm here to tell you what most of these things do. Most of the proprietary software licenses spend the text to tell you what you cannot do with the thing you possess. You cannot make copies of it and give it to your friends. You cannot change it. You absolutely cannot even see the source code that comprises it. There are pages and pages and pages and pages of cannot, do not, must not. The copyright law in the United States and most of the rest of the world does not require that you do this. You do not have to do these things to protect your copyright. You do not have to do anything to protect your copyright. You can drunkenly scribble it on a cocktail napkin and wear it as a hat and run around naked screaming, "My copyright!" You can't lose your copyright. Open source shuffles the ideas in proprietary licenses around and says, instead of telling you what you cannot do, it tells you what you can do and gives you rights that are above and beyond what the law lets you do by default. The law in the United States gives everyone who has a copyrighted thing legally, which means if you steal it, the law is a little different. You cannot steal things from the store and go, "I have copyright rights," and run away, because that doesn't quite work that way. We'll just assume you have this thing legally. Open source extends that and says, all right, the only thing you have by default is the right to use the thing you have. It makes sense. You have it legally. You should be able to use it. Open source says you also have the right to distribute it, to modify it, and distribute the modified version without restrictions. That without restrictions part is where most people fail at licenses when they're trying to do open source and free software, and we'll get to that when we get to the really fun ones. So the open source definition is what the Open Source Initiative, or OSI, defined based on the early Debian guidelines that Debian was building for defining what they thought was going to be acceptable. And they ended up sort of going that way, and Debian went that way, and the Free Software Foundation's over there. But technically, anything that is open source is something that is available with free redistribution, source code, permission to make and distribute derived works, no discrimination against persons, groups, fields of endeavor, no secondary license requirement, a license that does not require inclusion of a secondary work. It must not come with a copy of, say, Pink Floyd's The Wall, although that would be sweet. A license that does not restrict other software, and a license that is technology neutral. And since someone's going to ask, let's just get the free software stuff out of the way. Free software goes farther. Free software says use, distribute, modify, but when you modify, you must then start to be very strict about how you do this. And then the idea in free software, the core of free software, the freest of free software, is copyleft. And the idea behind copyleft is that the license forces everyone participating to play by the same rules. Now, in open source, most people play by the same rules by default. I pick this code up, it's open source, I give it back to you with the changes, it's still open source. Most people do this just matter of fact, they don't think about this. But the license in copyleft licenses forces you to do this. It says you must do this. Free software was just structured around the idea that people cheat. People lie, people don't read licenses, people don't like to follow the rules, people like to get away with stuff and steal from other people. And the license is structured in such a way to try to make that practically impossible. So it is helpful to remember that effectively, and this is not true, there's all sorts of counterexamples in weird cases, but for the purposes of this very brief talk at the end of the day on scale, all free software is open source, but not all open source is free software. The term free software was coined by Richard Stallman in '85. Richard went on to create the Free Software Foundation, which is a nonprofit dedicated to promoting software freedom and protesting DRM and doing all sorts of other valiant and noble things. They also created the free software definition, which defines 4 freedoms. It was 3 for a while, and then it became 4, and then it was kind of 5, but it's 4 now, so it's just 4. All right, so because they're hackers, and we respect that, they start with 0. Freedom 0 is the freedom to run the program as you wish for any purpose. Freedom 1, the freedom to study how the program works and change it so it does your computing as you wish. Freedom 2, the freedom to redistribute copies so you can help your neighbor. Freedom 3, the freedom to distribute copies of your modified versions to others. Again, very, very similar to the open source definition. All right, more terminology for you. Trademark, a distinctive design, picture, emblem, logo, or wording, or combination, used to identify a product and/or its manufacturer. Patent, noun, a set of exclusive rights granted to an inventor for a limited period of time in exchange for public disclosure of their invention. I prefer the definition patent adjective, which is obvious. This is the legal law definition for patent. This is legalese, it's not English. Trademarks are branding. A trademark says, this thing that you hold in your hand, I made it. The idea behind trademark is that consumers will see it and attach a positive connotation to the product bearing the trademark. When you see the Coca-Cola trademark on a bottle, there are quality and flavor expectations you immediately have, assuming you have a Coke before. You do not expect it to contain sewer water, for example. Whereas, if you pick a random bottle off of the shelf at the Costco, and the label says, Jim Bob's Sewer Water, Cola, it probably is not going to give you that Coke experience. Now, trademark differs from copyright in one big respect. Trademark holders are required to proactively protect their trademark from infringement. They can license it for other people to use, but they cannot license it for anyone to use however they choose. That's legal terminology for a naked license, which sounds like it would be way more exciting than it is, but it's not. If you do this, it can result in the abandonment of the trademark and the inability to protect your brand. It means anyone can do anything they want with it at any time. So, I don't normally like to throw communities under buses, but I'm going to do it very briefly. For a very long time, Debian was running a naked license. Anyone who wanted to do anything they wanted with the Debian marks could do so freely. You could put Debian on a towel, you could put Debian on underwear, you could put Debian on a condom, you could put Debian on a car, anything you wanted to do. And people did this. And most of the people did this in a well-meaning way. They did not mean it to be an abuse of the brand. They were putting Debian on shirts and mouse pads and stickers and fun stuff. But literally, if you ask Debian, can I put the Debian logo on the thing? Sure, whatever. Doesn't matter. We don't care. Do it. Now, practically, does this affect Debian in any meaningful way? No. But should Debian ever decide that they do not wish to be listed as the co-sponsor of the KKK's annual summer, barbecue, they can't stop that. That trademark has been under a naked license for so long, and it's not anymore. It's not anymore, but it's been under it for so long that I could get the right lawyers and go to court and say, look, they can't stop me. The whole point of trademark is that someone has to keep saying, hey, no, stop running, no. So when you see people enforcing their trademark, and there's way more heavy-handed ways of doing this than the gentle, polite way that Red Hat does, which is basically like, we tell people, hey, bro, that's not cool. Don't do that. Some people will send these lengthy cease and desists and get mocked endlessly on the internet, but the core concept is that companies have got to do this, or they'll lose their trademark. All right, patents. Section 8 of the U.S. Constitution grants Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This is the fundamental core concept behind patents in the United States, to promote progress. Patents have a term. They're not forever. Term means the period of time that the patent is valid. Calculating this term is almost as tricky as doing your taxes. But as a general rule, patents filed on or after June 8, 1995, when the last major patent law reform of any significant consequence was passed, they have a term of 20 years from the earliest claimed filing date. Now remember, in 1995, most of us did not have fast internet. Internet was a thing that you could sit and watch your picture download pixel by pixel by pixel by pixel by pixel. So our digitally interconnected world was not as digitally interconnected back in those good old days. So keep that in mind when you remember that somebody thought 20 years was a good amount of time to protect a patent back in 1995. Now, when I talk about patents, I am always oversimplifying the discussion. I am making it colorful for the purposes of a general understanding of the ideas behind it. Patent law is freaking complicated. It is not simple to understand it, and patents are intentionally written to be confusing to lawyers, much less to humans. They include artwork like this. And literally, this is not actually in a patent. This is a humorous vision of a figure from a patent. But when you take the legalese that is in one of these actual patents and you translate it back into English, this is roughly what you get. And this is intentional, because patents, specifically in software more so than perhaps other areas, are written to be obscure and yet universal, which is a weird dance to try to strike, because it has to be obscure enough that someone at the patent office thinks, well, that sounds like it's kind of clever enough. Okay, that works. But universal enough that you can run around saying, I patented that. Look, you're doing that. You're doing that. You're doing that. It's like Oprah giving away things. It's ugly. And that's how patent lawyers like it, because the more possible applicability they can prove for a patent, the more money they think they can make. So this system was created by patent lawyers for patent lawyers alone. They are not out there to make your lives better in any meaningful way. Just accept that and move on if you find yourself having to do this. Remember, they are in it for them, not for you at any point. Patents are supposed to foster innovation. The Constitution tells us so. But software patents almost always have the opposite effect. In 2011, Yale Law estimated in a study that there are around 40,000 new software patents issued in a typical year. That was their estimate in 2011. There are some more recent studies that estimate that that number has doubled or tripled. Anyone want to wager a guess how many software patents Microsoft held in 1990? Zero? Nope, it's more than zero. It's not zero. It's less than 100 and less than 10. It is 5. They held 5 patents, and they announced this proudly in a press release in 1990. In 2009, in February of 2009, Microsoft publicly announced they had at least 10,000 software patents.
Didn't they have a bunch of submarine patents they hadn't completed yet? Like that and so forth?
Not in 90. Those patents weren't filed until later. They started aggressively filing file system patents in 92. No. And some of the patents they actually got through acquisition, so the other companies were filing them, and so they couldn't actually claim them. So sneaky, but if you look back to the 90s, or the 80s, and we go back in our time machine, we get in my little tiny TARDIS up here that you can all not see. It's bigger on the inside. We'll all fit. Most of the important enterprise software in wide use today rests on ideas that predate the explosion of software patents in the 90s. Lotus 123. 1982. Microsoft Word, 1983. Oracle, Version 3, really the first version that did proper SQL as we know it today, 1983. Windows 3.0, the modern graphical UI, ignoring the fact that they stole it from Xerox, but we will leave that alone. 1990. Patents are a big reason why we can't include free and open source license things in Fedora. It's the #1 reason I have to turn things away. It is my personal opinion, not necessarily that of Red Hat, that software known by the author to be encumbered by software patents, whether they hold those patents or not, is not free software or open source, regardless of the copyright license on it. This is a somewhat controversial opinion. You can find 4 or 5 people that are knowledgeable about licenses, and we will all disagree and throw food at each other. This is the stance I hold. Now, patents have a very high price. They're extremely costly. We are talking minimal $3 to $5 million in attorney's fees to fight a patent case successfully, with the possibility of enormous damages. In 2014, a jury found that Samsung needed to pay Apple for infringing 2 patents, $119.6 million for infringing 2 patents. Damages for patents are usually calculated based on the whole product rather than the value of the patented invention that's only part of the product, which in a software context means that anything that incorporated any part of your patent in any meaningful way, the biggest possible object that connects it will be what they calculate damages off of it for. So you may mock those high-end entertainment devices and audio equipment that cost thousands and thousands and thousands of dollars, but if your software ends up in there, that's going to be where they start calculating damages. Many patent lawsuits are quickly settled out of court due to the high costs of fighting it and the risk of extreme costs if the case is lost at trial. Most patent cases are filed in the Eastern District of Texas, where the average jury cannot use a mouse. Any of the jurors. This is intentional. This is on purpose. This is so the game is rigged against you when you try to fight a patent case. My hat is off to any company that fights and wins patent cases, because it is hard. All right, license super happy fun time. Enough talk about sad stuff. Let's talk about specific licenses. First one is the GNU General Public License. I could not find a good picture of anything relating to the GNU Public License that was under a Creative Commons license, so I found this picture of this lovely GPL audio video store somewhere. The GNU General Public License, I will henceforth refer to it as the GPL, is the most widely used free software license. It is estimated by multiple parties that anywhere from 50 to 65% of FOSS projects are GPL licensed. The GPL is the most well-known copyleft license because it explicitly requires others who modify your code and distribute to share their changes. The intent of the GPL is to ensure the preservation of the freedoms outlined in the free software definition in both the work itself and all distributed derived works. Now, because of the wide use of the GPL, there's also way more available information as to the compatibility between the GPL and other free and open source software licenses than for any other free and open source license. There's lots of people that want to know, is Apache compatible with Cuddle and all these other things? And there's lots of times the lawyers just go, but for GPL, they generally are able to know is there compatibility. Now, the GPL has evolved over time. The original GPL text was written by Richard Stallman based on the licenses being used in various GNU software tools at the time. But Richard, meaning well, is not a lawyer and does not speak legalese. And so the GPL v1 was not a very good license. It meant well, but it was worded poorly. And very quickly, people who do speak legalese informed him of this fact, and he corrected this by crafting the GPL v2 in conjunction with lots of other smart lawyers. Now, the GPL v2 is what most projects use today that use GPL, although that number is continually growing towards GPL v3. The third version was written specifically to solve some of the issues that were believed, perceived, or actual to be problems with the GPL v2 and to adjust to the changing world that we live in. So very briefly, the GPL v3 was written to make it easier to be compatible with other free and open source licenses. It contains regulations concerning digital rights management, and this is almost something I could give an entire talk explaining, but I'm going to summarize it like this. If you have code that's GPL v3 and you want to make changes to it, but DRM says you can't, you still can. That's it. GPL v3 has stronger protection against patent threats. It also requires that distributors provide users with all the necessary information to install modified versions of GPL v3 licensed software preloaded on a device. This is sometimes called TiVoization, based on what TiVo did. TiVo had GPL v2 code inside their device, but you had no way to actually modify it and put it back. Now, there are some people for whom, if I can get the slide to go slide, go. There we go. There are some people for whom the GPL is too restrictive. They want a little bit less. So we created the GNU Lesser public license. Originally the GNU Library public license, but Richard liked to make everybody know how much he hated that people had to use his other license, so he gave it a naughty name. This is a red panda, by the way, also called a Firefox or a Lesser Panda. And that's not a crack on Firefox. It's legitimately called a Lesser Panda. So the LGPL allows for the use and integration of LGPL software into other software without requiring that other software be released under strong copyleft terms. Primarily used for libraries, it was developed as a compromise, so people who liked the idea of the GPL for their code but didn't want to force other people to have to play by those rules have LGPL as sort of a compromise. A good lawyer friend of mine once told me no one actually understands how the LGPL works. Everyone just assumes it works the way they want and no one really cares, so we all roll with it. Getting lawyers drunk and honest is fun. All right, permissive licenses are the other common licenses in free and open source software. They are licenses which are designed solely to grant permissive rights to users. As a result, they tend to be shorter than copyleft licenses, but this is not always better. Permissive licenses usually require the following: that you retain the copyright notice, you disclaim the copyright holder of any and all warranty, and in return, they explicitly permit use, modification, and distribution. The most common permissive licenses are the BSD license, or licenses. At current time, we are tracking about 22 variants of the BSD license in play in Fedora. And the MIT license, or licenses, sometimes called the X11 license. There are more than 75 variants that we are tracking of the MIT license. Now, if you subscribe to the SPDX philosophy of licensing, then each one of those is a unique and special snowflake license and gets its own name. In Fedora, we just call them all BSD or MIT, and we just keep going, because we don't got time for that. The biggest advantages to permissive licenses is their compatibility. They are generally considered to be universally compatible with all other free and open source licenses. The biggest disadvantage is that their very structure allows, some would say encourages, for anyone to take their code and redistribute it in binary form without ever releasing the corresponding source code, whether that code has been edited or not. Which means that all I have to do to make a permissively licensed code proprietary is refuse to give you the source code to it. I can download it off the internet, hand it back to you, and go, nope, no source code, don't know where that is. Now again, if you're smart and you're clever and you're able to find the copyright notice that they've somewhere included, because it does require that you retain the copyright notice so that you know it's BSD and you can go hunt it down and try to find the source somewhere on the internet. Having said this, having had to do this repeatedly, I can tell you it's not enjoyable, because retain the copyright notice occasionally gets injected into metadata in an image so that they meet the requirement. Now, this is not hypothetical. There are many, many cases of permissively licensed software being distributed in a way that makes it effectively proprietary. The most well-known example is the networking stack in Windows NT4. Taken pretty much cut and paste from BSD. Now, the BSD license, the MIT license, is noteworthy in that most variants of it explicitly grants the permission to sublicense the work. Sublicense is legalese for the ability to apply additional license text to the work. So I can have something that is MIT, and I still have to comply with MIT. I still have to retain the copyright notice and disclaim the original copyright holder of warranty, and then I can apply a license text that says, the Apple iPhone EULA. Still complying with MIT, not having to give you any more of the source code, not having to do any of the other things, because I'm still in compliance with those bits up there, but the rest of my bits now apply. Effectively changes the license on the work completely to whatever I want it to, whenever I want it to. So keep that in mind when you see MIT and you're worried about compatibility. You can just slap your own license on it and you're good. Apache. Again, finding pictures for license names is kind of both fun and weird at the same time. So the Apache license is a permissive license, and originally it looked a lot like BSD in its first variants, that contains, in the current revisions, an express grant of patent rights to users. And at some point, somebody took what was BSD, which was written by one sad, lonely lawyer at the University of California, Berkeley, and added as much legalese as their little heart desired to it. So it's pretty thick. It has 10 defined terms. In a license, when you capitalize a term, it becomes a term, and it has a definition, and it means what it says and nothing else, no matter what the law dictionary says, because I have made a term. It implicitly says something interesting. It says, I am also a contributor agreement, which was the first license to try to do anything like this. It was roughly the equivalent of going through a license and discovering a text that says, I am also a cheese sandwich. That may be true. It is irrelevant, but thanks for saying it. But in Apache, the point was is they wanted to have one license they could use as a software license and then a contributor license. And what the Apache license says is that if you give a contribution to an Apache license project, and you don't put a license on it, we're going to assume because you had to use this code in order to make the contribution back that you're giving it to us under the Apache license. Now, to be honest, as someone that spends a lifetime looking for loopholes in these sorts of things, that's a loophole you can drive a Mack truck through. But for most of the Apache community, this works out pretty well for them because they legitimately do want to be in the spirit of Apache and giving things back under Apache licenses. Apache license also explicitly states that trademarks are not covered under the license, which is really funny because this is a copyright license and it's roughly equivalent to saying, I'm still a cheese sandwich, but whatever. Some lawyer got really excited and happy at the ability to add this. It is also not a nuclear weapon, but they omitted that. The Mozilla public license, I found a picture for MPL, I was so proud of myself, is a hybrid license. Mitchell Baker said, I want something that's like the BSD, but also like the GPL, but I also want to hook proprietary code into this. At the time, she had drafted something called the Netscape public license, which she thought was sweet, and no one else did. And so she said, okay, fine, I'll come up with something better. I got something better for you guys. And she came up with the MPL. And she goes, we'll do some stuff under Netscape public license. We'll do some stuff under MPL. Nobody's using Netscape public license anymore. Not even Mozilla, not even any of those folks. So MPL says that you can take code that's MPL and you can mix it with other licensed code, even proprietary code, but you got to keep that MPL licensed code under the MPL and freely available in source code form. It also includes a patent grant for the work, and interestingly, one of the first licenses to include a patent termination clause, which says, if you sue us for patent infringement, you lose all the rights we gave you in the license. Ha ha. Now, does this hold up in court? Nobody knows. It also explicitly disclaims applicability to trademarks. Why? Probably because they saw Apache do it. Again, it's a no-op. It doesn't mean anything. But they did it. It's in there. Lots of other licenses have copied from other licenses thinking that people were smart when they wrote those other licenses and it must make sense for me to have it in my license. I got to have it, and it doesn't mean that. It just means it was fun to copy. Lawyers love to copy. The current version of the MPL as of 2012 is MPL 2.0, which was reworked by some very smart, very talented people to make the license clearer, easy to apply, and more compatible with other FOSS licenses. For a very long time, there was concern about MPL being compatible with GPL and Apache, and those days are gone. Thankfully, MPL 2 solved all those problems for us. Now, this license was written by lawyers, and these lawyers love legalese so much. It is a good license. I'm not trying to pick on it. But my God, trying to parse through that, if you don't speak fluent legalese, you're going to get it wrong. Mozilla provides a FAQ on their website that is twice the length of the license. Now, the MPL is often released in a tri-license, where works under the MPL are also available under the GPL or LGPL. Now, let me stop and explain this briefly to you. This part is a little bit tricky, and I could give a whole talk on it. Some code is under multiple licenses, where the end user can choose which license they wish to be bound by. This is called an OR situation in computer programming. The Perl license is a good example of this. It provides the user with a choice of the GPL or the Artistic 1.0 license. Now, since the Artistic 1.0 license is one of the few licenses that has lost in court in the United States, and the Perl people hate it when I say this, and I'm not trying to pick on their license. It's a wonderful license. It means very well. And they have fixed it in the revisions after that. And it did end up winning on appeal. So we pointed all that out. But generally everybody looks at the Artistic 1.0 license and says, this is non-free. We know what you're trying to say, but it's non-free. The open source initiative said, hey, we still think it's okay because we're, you know, a little more easier going on things. So you got a choice. You got GPL or Artistic 1.0. Users who wish to use only free software and avoid this questionable license can use it under GPL. Users who are all cool and laid back and are okay with Artistic can use Artistic. It's your choice. You choose at any point in time. They're both there in this quantum state. You can pick and choose whichever one you want to apply at any given case. Which is funny because if you get sued for one, you'd be like, I wasn't using that, I was using that. Other code is under multiple simultaneous licenses. This can occur when code is copied into an existing project under a different license. This is called an AND situation in computer programming because all of the license terms must be honored simultaneously. For source code, this is usually pretty possible because you can separate out the source code and either in separate files or comments or all sorts of ways and say, that's that, that's that. But in a binary, it's almost always impractical or impossible to actually do that. So to oversimplify with an analogy, because that's fun, if one license says you must only paint your house blue, and another license says you must only paint your house red, you cannot comply with both at the same time. The resulting binary is non-distributable and non-free unless you are the copyright holder for all of the things inside of it. And then you can do whatever you want with it. You can wear it as a hat and run naked through the streets. The simplest way to avoid that state is to ensure license compatibility within the scope of a code base. Sounds simple, right? It's not. But if GPL is one of those licenses, it's generally simpler than every other case. Now, public domain is one of those topics that always comes up, so let's get it out of the way. Let's do it now. Public domain is not a license. A work which is considered to be in the public domain is a work which is not under copyright. This occurs when one of the following states happens. The work is created by the United States government. The term of the copyright has expired. Note, this no longer happens in the United States. Or the copyright holder has abandoned their copyright, explicitly and clearly. Now, this is a very tricky concept for a number of reasons. The most obvious is that many places in the world, including most of Europe, you can't actually abandon your own copyright. You can abandon some of it in some places, but not all of it. In France, you can't abandon very much of it at all. People who have said, I abandoned my copyright, have been told by the court you didn't do that. You can also not assume that any work generated or distributed by the U.S. government is in the public domain, as they have a number of loopholes around this, the most simple being by hiring a contractor to do the work. Because he's not the U.S. government, he's a contractor. As a result, the U.S. government employs more contractors than they actually do employees to get around the public domain. Now, if you really are in that anarchistic state where you don't want anything to do with your work, you don't want that copyright anymore, you want the man to just do whatever they want with it, there are ways to do that are not putting things in the public domain. The most obvious way is to put something under what's called the Creative Commons Zero license. The Creative Commons Zero license is what happens when you lock lawyers in a room and you tell them you will not feed them until you come up with the legalese that is the rough equivalent of public domain. It's lots and lots of legalese, and you're parsing through it, and as you work through this and translate it back into English, it all sums up into you can do whatever you want with this thing because it ain't mine anymore. Great, we have a license that does this for me. Another way of doing this is to use a permissive license with a warranty disclaimer, because one of the things people forget about public domain is you may not actually be disclaiming the warranty on it anymore, and someone may come and sue you for it, and you might be liable still. So think about that before you shove something in the public domain. Picking Creative Commons Zero or a permissive license is probably a better way to go. Now, documentation often has source forms which get transformed and manipulated into other forms, so it kind of looks like software. There are a number of free and open source software licenses that are specifically written to cover the unique nature of documentation files. There's not a ton of these, but there's a couple. More often than not, what you see is that the software license applied to the work also applies to the docs. And for most intents and purposes, this is good enough for government work. We just roll with it. But there is the GNU Free Documentation License, which is specifically written for that. Debian uses that quite a bit. There's also Creative Commons licenses, which I'll talk about in a little bit, and the Open Publication License. Font licenses, fonts aren't software. They sometimes have source and they're sometimes compiled, but they're not really software in the same sense that like Firefox is. Fonts get embedded into documents all the freaking time. If you put a copyleft license on a font, you're probably going to make everyone have a bad day. And that's not because we think copyleft is a bad idea, it's just because fonts aren't software. Your best bet is to choose a free font license like something like the SIL Open font license, if you're going to do fonts. If you still want to do GPL, there's a standard font exception boilerplate text that people add to it to make it more kosher for documents and for font use. Content licenses, when I say content, I mean things that are not code, not docs, not fonts, art, music, sound, video, creative works that are copyrightable but don't have source code to speak of in a real way. You usually get them in one format, and you can usually manipulate and remix and modify them directly. And again, I'm oversimplifying when it comes to video because there are encodings and things like that, and you can really tear this apart, but just roll with me, okay? The best choice for these licenses are a family of licenses called the Creative Commons licenses. They were created specifically to deal with content. CC BY, Creative Commons attribution, specifies only that you give attribution to the copyright holder and lets you run free for the most of it. Creative Commons attribution share alike says, give me attribution and then all of your derived works must be under the same license, so this is the copyleft of the Creative Commons family. There are other Creative Commons licenses, but they're not free and they're not open source, mostly because they tell you what you can't do. Quickly, yes.
Is there any notable reason not to use a Creative Commons license for software?
They're not designed for software, and they're not as good of a fit as a software license would be. They cleaned up some of that in the 4.0 series of rework, but it's still a better bet to have a software license for software and a Creative Commons license for content and not try to cross the streams. We all know what happened in Ghostbusters. Yes?
What if your software isn't binary distributable? It's something like a scripting language and it's only distributed in source form. Is a software license still better for that, or is Creative Commons more applicable?
Usually, because the wording around it is more directly applicable for software, the line gets blurrier there, but in general, if you had to go to court and you have a Creative Commons license that's talking about content and digital right to perform, the judge may go, what the are you smoking? Versus a software license where it's clearly intended for the work you put it on. Remember, all you have to do is confuse one judge that can barely send email to lose. All right, I know you came for the crazy licenses. Here's some of the weirdest stuff I've seen. The JSON license. The JSON license is a permissive license in all regards, derived from the MIT license, except for one added clause. The software is a term in caps, shall be used for good, term in caps, not evil, term in caps. Now remember, licenses are written in legalese, not English. When you capitalize a word in legalese, that word is special, it is a term, it is supposed to have a definition, either in the law dictionaries or provided by the legal document itself. There are no legal definitions for good or evil in law dictionaries or in the license. What makes use good or evil? Who knows? An argument can be made that the copyright holder is the only one who can answer this. Another argument is that it cannot be answered at all. This is deep, folks. Either way, it means that practically no one can safely use this software. Now, the creator of this license is aware of this complexity, and it amuses him to no end. IBM, ye of fleet of lawyers, came across the JSON license because one of their components had it inside of it that they acquired from somebody who acquired it from somebody who ate it from somebody else. And they discovered this, and they thought about this for a while. And they thought long, and they thought hard about what is good and what is evil. And then they remembered they were lawyers, and they thought no more about this, and they went to the guy, and they said, how much will it cost for you to strike that clause from it? And he said, I shall not. I will not bend to you or any other mega corporation. And he said, but what I will do is I will specify that I permit IBM to be evil. So they crafted custom wording that permitted a loophole to be created in the IBM revision of the JSON license, allowing IBM to document itself as evil but okay to use JSON. Obviously that scales poorly, but... All right, the XTLD license. The XTLD license inherited the XJS software license, which is GPL v3, which is cool, and you think, why am I talking about this? Should be straightforward okay. However, to download XTLD, You also have to agree to an additional license where you agree to not develop or manufacture products which involve animal testing, not participate in the animal testing industry, not produce any products which involve any animal product, byproduct, or derivative, not produce any GMOs, not be involved with or profit from the use of animals for entertainment, not be involved with the breeding or transport of entertainment of animals for any of the previous conditions. Look, I don't want puppy mills or greyhound races or anything like that. But I like bacon. And if you're a vegetarian or a vegan, more power to you. But these use restrictions make EXTLD non-free, non-open source.
You have to pass this on. I have a vegan friend download it for me.
Unclear. The DNR license. D stands for death. R stands for repudiation. And the license states that, and I quote, the software may not be used directly by any living being. Yes, my friends, you must be dead to use software under this license, and if you aren't dead, you will be punished to the fullest extent of the law. If you are a ghost or an angel, you may also not use those licenses because you are considered to not be in that not living category. You're somewhere in the middle and you still don't want permission. And the good news is that this license, while completely absurd, is part of an OR, multi-license case, in the only known instance, and the other license is BSD. So this is generally just there for your amusement. The WTFPL. If there is anyone in the room in the last talk of the day who is uncomfortable with naughty language, please cover your ears for a moment because we are going R-rated. The do what the fuck you want to public license only has one real clause in it. You just do what the fuck you want to. This is not written in legalese, it's written in English because you can't all caps terms in legalese. But really, this license is written pretty poorly. What legalese it does have, the tiniest little bits that it does have, strongly implies that the license actually only applies to its own text and not the software it's under. Nevertheless, the intent of the license is crystal clear. All right, the CDL. This is the chicken dance license, not to be confused with Apple's Common Documentation License or Sonical's Common Development Distribution License, which we usually call CUDL. The CDL is a BSD-derived license with the following additional clauses. An entity wishing to redistribute in binary form or include this software in their product without redistribution of this software source code with the product must also submit to these conditions where applicable. For every 1,000 units distributed, at least half of the employees or persons affiliated with the product must listen to the Der Intertanz, aka the chicken dance, as composed by Werner Thomas, for no less than 2 minutes. For every 20,000 units distributed, one or more persons affiliated with the entity must be recorded performing the full chicken dance in an original video at the entity's own expense, and a video encoded in OGG Theora format, or a format and codec specified by the owner, and at least 3 minutes in length, must be submitted to the owner, provided the contact information is available and included with the license. Any and all copyrights to this video must be transmitted to the owner. The dance featured in the video must be based upon the instructions on how to perform the chicken dance that you should have received with this license. Any employee or person affiliated with the product must be prohibited from saying the word, and I apologize for mispronouncing this, Gazorninplat in public at all times, as long as distribution of the product continues. And furthermore, they disclaim any liability for you injuring yourself while attempting to perform the chicken dance. This is what happens when lawyers get drunk and bored. Look in GitHub and find out, my friends. The Solipsistic public license. This license requires that you accept that nothing besides you exists, including the software, the copyright holder, or even the license itself. I find it incredibly difficult to comply. Now, we've gotten the fun stuff out of the way. Choosing the right license for you. We are over time. If anyone wants to run away and go to the bar, you are welcome to do so at this point, and I will think no ill of you. Choosing the right license for you is hard. There is no magic answer. Anyone who has a magic answer for you is probably wrong. It's like asking the Pope which religion to practice. They're going to give you the answer you expect from that person. If you ask Richard Stallman what license you should choose, you already know your answer before you asked it. If you ask anyone on the OSI license committee what license you'll choose, it's a very high probability they will come back with the license they wrote. It's just how this works. If you get Larry Rosen to be your lawyer and you ask him which license should I use, he's happy to hand you the ones he wrote. Everyone working in the free and open source licensing community has a license they prefer over another. We are biased in that way because of what we deal with and what we work with and what our common beliefs are. There is no right answer. However, there are plenty of wrong answers. The most wrong answer you can possibly have is, I'm going to write my own license. Fedora has 350 plus free licenses that are unique and different and magical and awful. The chances are very, 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 very slim that you are qualified to write your own license, that the things you want your license to do will be free and open source, and that no other license already serves those needs adequately. You are already like the best corner case in the universe if you've met all of those three criteria. So don't do it. And also, don't go changing just part of a license either. The most common mistake people make is they assume the license is written in English. And I'm going to change this to be better understandable by other people because I know what that meant. You don't know what that meant, and by changing it with English, you made it not valid in court. And all you have to do is show up with a license that's not valid in court and go, well, that license isn't valid, so all you have is what's under U.S. copyright law, which is nothing. Don't do it. Choosing a license is a philosophical choice. If you wish to simply permit others to freely use, modify, and distribute the work, pick a permissive license. We talked about the downsides of that, but you can do it. If you wish to ensure that changes to your code stay under the same license, pick a copyleft license. GPL is a good choice. If you're concerned about patents, you want to consider a license that has explicit patent clauses like Apache, Mozilla, or GPL v3. If you want your code to be copyleft but also permit other code under any license they wish, even proprietary, to depend on it, LGPL or Mozilla are structured specifically to permit that. If you're building a web application and you want a strong copyleft, a Faro GPL is built for that. There are a fair number of license choosers that are out there. Again, if you go to the Free Software Foundation's license chooser, they're going to point you to the GPL. It's just going to happen no matter what you check. But there are some that try to be reasonably minimal in their bias. ChooseAlicense.com is GitHub's. They have some bias towards other licenses, and it shows, and people nitpick that all day long, but it's a good start. They're generally well-informed and honest about the licenses and help you get to where you want to be with what you believe in. Creative Commons has a chooser at creativecommons.org/choose that's very good about helping you pick which Creative Commons license is right for you. Now, would you like to know more? Hopefully the answer is no. I'm getting the hell out of this and going to the bar and drinking all this thought away. But if for some reason you said yes, there's a fantastic book that's been in print since 2008 by a good friend of mine named Van Lindbergh, who is a lawyer, and yet I still like him. It's called Intellectual Property and Open Source, A Practical Guide to Protecting Code. It's well written, it's clear, and it parses for both lawyers and humans. If you really want to delve into this dark, dark pit of pain, this book is a great guide. And with that, I'm way over time. Thank you so much for joining me for the last session of the day. I will take any questions that you give me until they throw me out of the room. Thank you. Okay, go.
Internationally, are all these licenses respected, and how do you protect yourself if they're not?
Okay, question. Internationally, are all these licenses respected, and how do you protect yourself if not? The answer is sometimes. Some licenses have been proven internationally. The GPL is generally considered to be applicable in all jurisdictions known in the world where the Berne Convention is applicable, which means there's like 6 or 7 countries where it doesn't apply and copyright is just funky as hell. But for the most part, those licenses are good. If you're concerned about this, you want to look and see if that license has been reviewed by lawyers in that jurisdiction. Generally, if a license has been proven good in one European jurisdiction, it's approved for all of them. Generally, if a license has won a court case in another country that the Berne Convention upholds, you will have enough grounding to move it against. Another good look is to see if a license has been legally translated, not just translated by people who speak English and French, but also by a lawyer. A legal translation is different from a straight English to other translation because it's different. They're translating legalese into French legalese. And that's why legal translation costs so much. Some licenses have had their text translated. The Creative Commons licenses have been translated into a number of other licenses by lawyers so that they are proper. If you are really concerned, look to Creative Commons licenses. But for the most part, you're not going to find problems in one jurisdiction or another based on the license if the license is well crafted. It is poorly crafted licenses that have problems in some jurisdictions. The exception to this is China. Chinese lawyers want that license to be in Chinese legalese. They do not want to see English legalese. They will refuse to accept that license under a foreign text. So if you are planning on doing business in China, pay a legal translator to translate that license into Chinese and then give that back to the rest of us. That is the one corner case. All right, go.
Has the Apache patent protection thing ever been successfully tested before?
Not in the United States. The question was, has the Apache license patent protection ever been tested in court? Sorry.
Has anyone translated GPL to Chinese?
I think so. I haven't seen it, but I wager it's been done and somebody just hasn't shared it. Again, IBM does business in China.
You could write to licensing at uni.org. That'd be the best way to do for that one.
Did they translate evil to Chinese? They don't need to.
That concept may be universal. I don't know. Anyone else? Any other questions? Yes, in the back. Hold on. I'm going to take a deep breath. All right, go. You can buy me a beer, and we can talk about this later. I don't want to use profanity openly in front of too many people tonight. Anybody else? Great. Thank you for coming. Enjoy the bar. Enjoy Week of Ski.